All right, let's dive in. We're tackling rules 34, 35, and 36 of the Rules of Civil Procedure today. You know judgment on the pleadings, summary judgment, and judgments and final orders, right? Especially if you're prepping for the BAR exam, those should definitely ring a bell.
Absolutely. These rules are super important. They can really make or break a case sometimes, even before it goes to trial. We're going to break them down, look at some examples, and hopefully get you ready for those BAR exam questions.
Okay, so imagine you're a lawyer. Your client comes in with, say, a contract dispute, wants to sue. You file the complaint, the other side responds, and bam, you're drowning in paperwork, all those pleadings.
Yeah.
But what if you could wrap it all up right then and there, just based on what's in those documents?
That's where Rule 34 comes in, judgment on the pleadings. It's like saying, look, even if everything the other side says is true, the law's on our side, clear as day.
So it's a way to speed things up if the legal issues are obvious just from the pleadings.
You got it. But there's a catch. For the defendant, if you don't fight a motion for judgment on the pleadings, you're basically saying you agree with everything the plaintiff said. You're putting all your eggs in one basket, just those pleadings. Miss one tiny detail, one little fact that's disputed, and you've basically given your opponent a map to discovery, and the case keeps going.
Whoa, high stakes. Our source material, 2024 Golden Notes Remedial Law Rule 3436.pdf, mentions a case, Sunbanan versus Go. Seems kind of unusual. The defendant actually asked for the motion.
Yeah, it shows how judgment on the pleadings can be a two-way street. Sunbanan, the defendant, said the whole case came down to how you interpret the lease agreement, legally speaking. They were sure they were right, even if everything the plaintiff said was true.
And the court agreed.
Yep, they did. But remember, you don't see judgment on the pleadings all the time. It only works when the legal issues are totally obvious just from the pleadings.
So, what if a motion for judgment on the pleadings is denied? Is that the end of the road?
Not at all. It just means the case moves on to the next step. Parties start gathering evidence, talking to witnesses, all that trial prep.
Okay, makes sense. So judgment on the pleadings is like a shortcut, but you can't always take it, and it's not a guaranteed win. Speaking of avoiding trial, let's move on to Rule 35, summary judgment.
Now with summary judgment, we're taking things a bit further. It's not just about the pleadings anymore. Now we're looking at other evidence too, like sworn statements, documents, maybe even video footage.
So we're going beyond what's written and actually seeing if there's something real to argue about.
Exactly. And here's where this idea of a genuine issue of material fact comes in.
All right, break that down for me. What's a genuine issue and what makes a fact material?
Think of it like baking a cake. A material fact is a key ingredient. If you're arguing about flour versus almond flour, that's material, it makes a difference. But arguing about like the color of the sprinkles, not so important.
Okay, I get it. So material facts are the ones that actually matter for the case's outcome.
Right. And a genuine issue means there's a real disagreement about those facts, not just someone making stuff up. There's evidence on both sides.
So if there's a genuine issue of material fact, you can't decide the case based on paperwork alone.
Nope, you need a trial to sort out those facts. But if everyone agrees on the key facts and it's just a legal question, that's when summary judgment can be a powerful tool.
It's like the judge saying, look, you've both shown me what you've got, I've seen the evidence, no need to waste time with the trial, the law is pretty clear here.
Exactly. And we have some interesting cases in our source material. In Republic versus Aklubakib, the court actually went ahead and issued a summary judgment without either side even asking for it.
Great. Seriously, is that allowed?
It is. It shows that if the facts are undeniable and point to a specific outcome, the court can issue a summary judgment even if nobody asked for it.
Wow. So the court just stepped in and said, we're ending this right now, no more dragging it out.
Yeah.
That's wild. But then we have Philippines versus Garcia, where a summary judgment was actually reversed. What happened there?
Well, the higher court said the lower court messed up by granting that summary judgment. There were actually genuine issues of material fact that should have been decided at trial. It's a good reminder that summary judgment isn't a magic wand. You can't use it to avoid a trial if there are real factual disagreements.
This is making me realize just how tricky these judgment calls can be. It's like a legal chess match. You really got to think carefully about every move.
Great analogy. Speaking of judgment, let's jump into Rule 36, judgments, final orders, and entry thereof. This is what wraps up the whole litigation process.
So this is where the gavel slams down, case closed. But I bet there's more to it, right?
Oh, absolutely. It's super important to know the difference between a final order, which actually ends the case, and an interlocutory order, which is more like a step along the way.
So final order is like the end of the book, and interlocutory order is just a chapter break.
Perfect analogy. Now, For a judgment to be valid, there's a specific checklist. You can remember it as aju ad con per sign.
I love a good mnemonic. So we're talking about the court's authority to issue the judgment, A, adding the right parties, add, and of course, the judge's signature sign.
You got it. And super important, a valid judgment needs to clearly state the facts and the law it's based on. No vagueness allowed.
Why is that so important?
Because if someone wants to appeal, the higher court needs to understand the reasoning behind the judgment. A well-written judgment provides that roadmap.
Like a recipe, if the instructions are unclear, you might end up with a totally different dish.
Exactly. And once a judgment becomes final, it's pretty much set in stone. That's the doctrine of finality or immutability of judgment.
So no takebacks once the gavel drops.
Generally, no. But of course, there are a few exceptions. You can fix clerical errors, and in some extreme cases, if enforcing the judgment would be really unfair, the court might intervene.
So there is some wiggle room for fairness and flexibility in those extreme cases.
Exactly. The Antonio Orrego case in our source material is a good example of that. The court actually reviewed and changed a final judgment to make sure due process was followed. But these exceptions are pretty rare. The idea of finality is there for a reason. It keeps the legal system stable.
Wow, this is really making me appreciate how complex these judgment rules are. I'm starting to see them not just as technicalities, but as real tools that can actually shape the outcome of a case.
That's exactly it. These rules aren't just abstract ideas, they have real-world consequences. Understanding them is crucial for anyone dealing with the legal system.
This has been really insightful, but before we jump into some BR exam-style questions, why don't we take a quick pause? Grab a drink, stretch your legs, and we'll be back in a flash to put your knowledge to the test.
All right, welcome back. Now that we've got the basics down, let's see how you'd handle some BIR exam-style questions. Remember, it's not about just memorizing rules. It's about knowing how to use them in real situations.
Okay, ready to put my legal brain to work? How about we start with Rule 34, Judgment on the Pleadings. What kind of tricky stuff might we see on the BIKR exam?
Okay, imagine this. You get a question where someone's suing for breach of contract. Their complaint lays it all out. The terms of the deal, how the defendant didn't do their part, and the damages. Now, the defendant's answer says, yeah, they didn't do what they were supposed to, but they were waiting for the plaintiff to fulfill their end first. What do you think? Could a motion for judgment on the pleadings work here?
That's a tough one. The defendant's admitting they didn't hold up their end of the bargain, but they're also saying the plaintiff messed up too.
Right. And those little details matter. In this situation, there's a real disagreement who breached the contract first. To figure that out, you need more than just the pleadings, you need evidence. So, judgment on the pleadings wouldn't really work here.
Okay, I see how the examiners could try to trick us. You really have to pay attention to the facts and see if there's any real disagreement.
Exactly. Now let's switch gears to Rule 35, Summary Judgment. Remember, here we're not just looking at the pleadings, we're looking at the evidence both sides have. Ready for another hypothetical?
Yeah, hit me with it. Feeling a bit more confident now.
Okay, picture this. Someone's suing a store because they slipped and fell on a wet floor. They say the store was negligent, didn't put up any warning signs. The store files for summary judgment and shows security footage proving the floor was totally dry, no spills. Seems like an open and shut case for the store, right?
Yeah, that video evidence is pretty strong. I'd think the store has a good chance of winning.
Hold on. What if the plaintiff then brings in an eyewitness who swears they saw an employee mopping the floor just minutes before the fall? Now we've got two sides to the story. The video says one thing, the eyewitness says another.
Ah, I see what you mean. Now there's a real question about whether the floor was actually wet or not. To figure that out, you'd need a trial to see who's telling the truth.
Bingo! The BIR examiners love to throw in these twists to test your ability to spot those real disagreements that need a trial.
Okay, I'm definitely feeling better about handling those tricky summary judgment questions. What about Rule 36? What kind of challenges might we come across there?
One of the biggest things with Rule 36 is knowing the difference between final and interlocutory orders. Remember, a final order wraps up the case, or at least a big part of it, while an interlocutory order is more like a step along the way.
Got it. So let's say a judge denies a motion to dismiss. Would that be a final order or an interlocutory order?
It would be interlocutory. The case is still going strong. The motion to dismiss was just an attempt to end things early, and it didn't work.
Okay, so it's like hitting a bump in the road. You got to keep going.
Exactly. Now, what if the judge grants a motion for summary judgment in favor of the defendant? Final or interlocutory?
That sounds like a final order to me. The defendant wins, case closed. Right.
You got it. If it covers all the claims in the case, that's a final order. But watch out, the BAR examiners might try to throw you off with questions about judgments that are final but not enforceable yet, or situations where a judgment is only partly final.
Okay, so I need to be careful and really pay attention to how things are worded. Any tips for dealing with those trickier scenarios?
Definitely. First, focus on what the order actually says. Does it resolve a specific claim or the whole case? Look for keywords like dismissed, judgment rendered, or case closed.
So it's all about understanding the real impact of the order, not just the surface level.
Right. And second, don't get bogged down trying to memorize definitions. Instead, think about why there's a difference between final and interlocutory orders in the first place. What's the big deal?
Because it affects whether someone can appeal the order.
Right. Exactly. You can usually appeal a final order, but not an interlocutory one, unless it falls under a specific exception.
It's all starting to make sense now.
Mhm.
I'm seeing how understanding these judgment rules isn't just about passing an exam, it's about knowing how to navigate the legal system strategically.
That's the point. These rules are the foundation of civil litigation. Mastering them gives you the power to make smart decisions and fight for your clients.
This has been incredibly helpful. I feel much more prepared for those BIR exam questions, and even better, I understand how these rules work in the real world.
Glad to hear it. And remember, the goal isn't just to memorize rules, it's to understand the reasoning behind them and apply them intelligently. Now, let's move on to our last section where we'll highlight some key takeaways and give you some final thoughts to chew on as you continue your legal journey.
Welcome back for the final part of our deep dive into Rules 34, 35, and 36. We've really gone in depth, looked at all sorts of scenarios, and hopefully made these judgment rules a lot clearer.
It's been a great discussion. We've seen how these rules can be powerful tools to make things more efficient and fair in the legal system, but also how they can be tricky and require some strategic thinking.
Definitely. It's clear that knowing these rules inside and out isn't just about memorizing definitions. It's about understanding why they exist, how they can be used strategically, and what impact they actually have on cases in the real world. So as we wrap up, what are some key takeaways you want our listeners to remember?
Well, I think one of the most important things is to remember that these rules are all about finding a balance. They're meant to help resolve cases more efficiently, so not everything has to go through a full-blown trial, but they also have to be used carefully to make sure things are fair and everyone's rights are protected.
That makes a lot of sense. Like with judgment on the pleadings, it's a great way to streamline things if the legal issues are pretty cut and dry, but you can't use it to avoid a trial if there are actual factual disputes that need to be sorted out.
Exactly. And summary judgment works the same way. The court can look at the evidence and maybe even decide the case before trial, but only if everyone agrees on the key facts and it's just a legal question.
And then we have Rule 36, which is all about those judgments and final orders. It's about bringing clarity and finality to the legal process, right?
Precisely. A final judgment sets out everyone's legal rights and obligations and lays the groundwork for any future enforcement or appeals. It's like the culmination of the entire legal battle.
This whole deep dive has been really insightful. I'm amazed by how these seemingly technical rules actually involve so much strategy, critical thinking, and real-world consequences.
I'm glad you think so. And for those of you getting ready for the BAR exam, remember, it's not enough to just memorize the rules. The examiners want to see that you can analyze situations, apply the rules intelligently, and pick up on those subtle nuances that can make all the difference in a case.
So any final words of wisdom for our listeners as they continue on their legal journeys?
Yeah, I'd say approach these rules with curiosity and a critical eye. Don't just take them at face value. Dig deeper, question things, and consider different viewpoints. Remember, mastering these rules isn't just about passing an exam, it's about having powerful tools to navigate the legal system and ultimately fight for justice.
Well said. And with that, we've come to the end of our deep dive into Rules 34, 35, and 36. We hope you've enjoyed this exploration of civil procedure.
Until next time, keep learning, keep questioning, and keep diving deep.